Call him. Nick.
I can join you.
That appears on behalf of the petitioner. Not any accommodation has been sought for. Is this matter? According to justice, the matter is adjourned. Is this matter in the monthly list of November?
Shiva, I'm appearing for the state respondent.
That appears on behalf of the petitioner. It is represented. According to justice, the matter is adjourned. Is this matter in the combined monthly list of November? If you come up in the combined monthly list of November, top in member. Top.
I think 22.
22, my lord, I am appealing for the state, my lord.
Kindly, my senior is coming. Kindly pass it over.
I am appealing for the state, my lord.
Affidavit of service.
Bit of service. Already filed.
Allegation of encroachment and construction, unauthorized construction, my lord. Representation at page 24, my lord. I am for the state, my lord. Hold on. Service to-
Okay, yes. All have been served. Service. We have seen. Who are the private respondents?
Well, item number 21.
I'm in 25 now. Don't. The item number is 22 now. What happened?
Well, this was something. Who was not? Item number 21, my lord. I was coming, my lord.
Who is
there
for the
some
state?
problem in the court. Suddenly, it has been taken up. Well, can it be taken up sometime tomorrow?
Not tomorrow. It has gone to the combined monthly list of November.
There were some urgencies there in the matter. My lord, if your lordship consider, lordship, it can be taken up.
Nobody was there.
I mean, it was running. I will give them.
It is for the state.
I'll find it out. my lord.
ওটাকে একটু কে করে দিন তো কালকে
Munmun ছিল তো,
Well,
দেখো না।
may I find out who is for the state? Munmun Tiwari.
ask her to come in presence
Continue
of
with this, I will inform you. lordship.
তাহলে একটু পাস ওভার রেখে দাও সেকেন্ড হাফে যদি ভয় করো
Yes, sir.
এটা 21 ছিল না আচ্ছা 21টা পাস 22 ছিল আচ্ছা who is the সভাধিপতি
সভাপতি সাফ করা হয়েছে সভাধিপতি
হ্যাঁ, স্যার,
it is for respond numbers
1 2
1 2
লর্ডশিপ
5 and 6
লর্ডশিপ
8 executive engineer is you are also there 7 8 9
এগুলো ইঞ্জিনিয়ার অফ জেলা পরিষদ
11
মেলা
private respond number 11 private respond number 11 where is the service the service no track report nothing 615
Lordship, on the previous occasion,
wait
on
item delivered দেখো ঠিক আছে
জেলা পরিষদ
প্রাইভেট রেসপন্ডেন্ট হয়েছে
জেলা পরিষদ
Sir, private respondent की certification what is it?
Lordship, when the writ petition was served upon the private respondent, the track report shows that not claimed. Yes, item returned not claimed, unclaimed.
Hmm.
Kindly come page 8 of my executive service. Lordship, first of all, kindly see this certificate copy.
It's evidence
Never-
service. Evidence
what is this
I'm coming. Unclaimed, Lordship, kindly
page 8
page 8. This is the track report of the private respondent. Now, Lordship, the same address again as per the direction of your Lordship, I have served. Now, this is returned,
delivered
that is insufficient.
this was delivered
So, that's the two affidavit service. One is the
today you have filed one affidavit of service
yes.
615 615 delivered
This is the envelope. Envelope has returned insufficient.
Insufficient address.
Sorry, insufficient. But Lordship, the concerned South 24 Parganas Jela Parishad has started the proceeding. This is the letter, art letter. Started a proceeding and oh, wait, sorry.
We go.
in support of your claim the subject order belongs to South this is your case
The proceeding has been started. Now, my case is, Lordship, in my land, that is RS 123.
Huh.
Lordship, the private respondent raised construction, which is belongs to Jila Parishad. Now, Lordship, kindly consider section 160A, subsection 5 and 6. It clearly shows that Jila Parishad has the authority to initiate a proceeding against the Lordship, the unauthorized construction. Lordship, I am only today, Lordship, praying. The proceeding has been initiated. I have submitted all documents in terms of the letter of the Jila Parishad.
let the proceeding be taken to the logical conclusion
And kindly consider this section 1, kindly indicate section 160A, subsection 5 and 6 to conclude the proceeding.
Also, there is a direction to submit documents, my lord.
the
Correction with the
proceeding
above
will
mentioned
be
subject, you are hereby requested to provide
things will
document
be
in
taken
support
to
of
the
your claim.
logical conclusion as per section 160 capital A.
Upon
Yeah,
complying
will-
with this letter, madam.
Upon notice to the all parties.
In this letter, the authority concerned asks for documents, supporting documents, my lord. Let them produce the document, my lord.
Yes, I have already served.
affidavit of service filed on behalf of the petition is taken on record
Yes, this
by
document.
the present writ petition. The petitioner seeks direction upon the respondent authorities, particularly Jila South 24 Pargana Jila Parishad, respondent number 3, to demolish the unauthorized construction undertaken this RS plot number 123 is a road
This is Jila Parishad.
undertaken by the private respondent over a plot of land being RS plot number 123, Mauja Kagdib, jail number 39, sheet number 01, police station Kakdip Coastal District, South Chobbish Pargana, which is a road maintained by the South Chobbish Pargana Jila Parishad.
Oh, extremely silent. This is the subsequent development that police force has been asked for removal of the structure. They lot I have received proof.
কপি আছে এটা কি পুলিশ চেয়েছে ওরা
No, it.
You withdraw this writ petition. It is not required now. 10-3 order has been passed for removal. What remains then?
So then observe that already proceeding has been concluded in terms of the.
Then I have to hold that this writ petition has become redundant. Since an order has been passed for removal of the unauthorized structures in terms of 2 writ petitions has been passed. Fine. One.
Yes.
In one, there are 2 orders passed by this court. You see, there is a reflection of WPA 10162 of 2022.
No, this is another writ petition. My writ petition is 11792.
No, in the order you have placed before this court.
So this is the
It key দিচ্ছে।
all of
Here,
the-
it is 155 plot number 1।
এটা কি ডকুমেন্ট
কি বললাম? Mr. Prosenjit Mukherjee, learned advocate for the petitioner, contains that the private respondents have undertaken construction over the plot of land encroaching upon the Jila Parishad road. He informed the court that already proceedings has been initiated by respondent number 3, South Chobbish Pargana Jila Parishad. In view of the above, South Chobbish Pargana Jila Parishad is directed to, the writ petition is disposed of directing respondent number 3, South Chobbish Jila Parishad, to dispose of the matter and take it to its logical conclusion, dispose of the proceedings and take it to its logical conclusion in terms of section 160A of the West Bengal Panchayat Act 1973.
Okay.
In terms of section 160 capital A of the West Bengal Panchayat Act 1973 within a period of 6 weeks from date of communication of this order.
Okay, everybody service carefully.
এটা নিয়ে নাও, এটা দিয়ে দিন, দরকার হবে। Take this back, envelope. Take the envelope back. এটা রাখ, এটা রাখ।
Item 23.
Your Lordship, this is that matter where I was appearing for the Panchayat Pradhan.
24 I am for the petition.
23, I'm for the petition.
23. টা দিন, 1
23 and 24, my lord, this is analogous matter. The 23, the petitioner, my lord, is my lord, the occupier, my lord, is the subleasing in respect of my lord, the premises which belongs to the, my lord, the Panchayat authority.
is a
Sublease. My lord, the lease was given to one, my lord, Samuel Rai, and Samuel Rai was, my lord, subleased to me, my lord, in respect of that premises. My lord, I have annexed the document to the extent, my lord, with regard to, my lord, the sublease.
What is your name?
My lord, my name is, my lord, Somnath Maiti. What the petition document?
Then who is Sudeep Khara?
My lord, this Samol Rai was, my lord, hand over this, my lord, to one Sudeep Dhara, and Sudeep Dhara is hand over to me, my lord, the Somnath Maiti.
So this will go on. This is go on like this.
My lord, what is happened initially, my lord, when the lease was, my lord, handed over to the Manik, the Samol Rai, my lord, this Samol Rai, my lord, could not, my lord, maintain, my lord, these, my lord, the premises. My lord, due to, my lord, his some financial, my lord, crisis, my lord, he handed over to Maiti, and Maiti, my lord, to Sudeep Dhara, and Sudeep Dhara to Somnath Maiti. My lord, all along, my lord, I am maintaining these, my lord, these premises, and my lord, I am paying the, my lord, taxes to the, my lord, the Panchayat authority, and Panchayat is accepted my taxes. My lord, your lordship kindly take travel to, my lord, the tax receipt I have annexed in, my lord, the Panchayat has accepted the tax from me, my lord. Kindly see, my lord, the tax receipt at page, my lord, 35.
This is a trade, no?
No, this is a trade license.
Trade license issued, my lord, in
Okay.
favor of me, my lord, Somnath Maiti. Kindly come to the bottom portion, my lord, the from, my lord, Sindhu Nibas. My lord, got it, my lord?
Hmm.
The name of the trade, Sindhu Nibas. My lord, with regard to, my lord, the area for the period of 2025 to 26, 26 to 27, 27 to 28.
So this is for running a hotel.
Hotel. This is the hotel, my lord, the Sindhu Nibas. That is the
Come on. Where is your name?
my lord, Somnath Maiti, my lord, kindly come to the left hand column.
This is June 25. June 25. Okay.
And my lord, thereafter, my lord, I made a representation to the Pradhan on page 36. But apart from that, my lord, I have a one document, my lord. On page 34, with regard to the document, page 34 also, my lord, with regard to the document which is issued by the, my lord, Diga Sonpur Development Authority addressed to me, with regard to, my lord, certain direction was compliance of certain direction. So, my lord, admittedly, the Panchayat has accepted tax from me in respect of the, my lord, the, with regard to, my lord, the registration of, my lord, the Sagar Nivas of the hotel for the period of 2028, and, my lord, there is a certain direction also to I have to, my lord, comply with in terms of the Diga Sankarpur Development Authority. Now, my lord, I made a representation, page 36. Page 36 is the document with regard to, my lord, I pay for. This, my lord, I made, my lord, huge investment for the infrastructure of this, my lord, the hotel. And, my lord, initially it was not running properly, but none of them, my lord, is carrying on any business. So, my lord, I invested a huge sum, my lord, and
You have not been granted lease.
my lord, the lease was, my lord, subsequently transferred to the lessee by the, my lord, the who has been granted the lease.
But then your possession is illegal now. Because
But, my lord,
private parties have entered into
but, my lord, they
sublease
have accepted
without the
my lord, they are accepted the rent towards me, my lord. But, my lord, even if
the right over the property.
my lord, these with regard to my possession, my lord, they have right, my lord, they have accepted the rent from me, my lord, tax, my lord, in respect of 2028.
But your possession in the said property without the knowledge and consent of the Panchayat.
The Panchayat is accepted the tax.
Person with whom you have entered into sublease was not authorized by the Panchayat that he, in the event he fails to continue with the lease, he can sublease to a third party. No such. No such clause is there.
There is
It is a private arrangement between the parties over a property belonging to the panchayat.
but the panchayat is accepted with regard to tax with respect
No,
of.
First, you clarify this situation that you are in possession of such a property which has not been authorized by the panchayat for holding the possession.
Since I have know that with regard to this lease in favor of the Samuel Rai issued by the granted by the panchayat, I made an application also to the panchayat to kindly handed over to the copy of the lease, because whether the lease contains of any such clause or not, that is I have to produce. But today your lordship kindly appreciate I am in possession with respect to whether illegal or I am in possession. Now Now kindly come to the allegation. What is happened? Since I am in possession, whether legally or assuming your lordship is I am in illegally possessing a property, but I should not be thrown out by this way. They what is happened without initiating any proceeding against me for eviction. They issue the tender process, and they issue the tender are issued, and the worker also issued in favor of some person. I have been not been any document to hand over the possession in favor of them. They initiated no proceeding against me. In contrary, I made a representation. We have in full knowledge of that property that I am in possession, and 9th of June, I made a representation before the Pradhan. Pradhan could have asked Pradhan, directed me, no, your application for reconsideration is rejected and you hand over the possession. That has not been done by the Panchayat Pradhan. In contrary, what we have done, he, my lord, initiated a tender process, and my lord, he floated the tender, and the person, my lord, who has been the writ petitioner of the item number 25, he has been granted, my lord, the tender in respect of the 25, where the panchayat is admittedly not in possession of the property. It is in favor of me. Now, you will also kindly take trouble to item number 25 once, 24. What is the pair of the 24, my lord? Kindly see that pair of the 24.
When a person who is holding the property without any authority of the panchayat, he is before this court seeking that you consider the representation.
No, my lord, two things was there.
So is it correct or not?
My lord,
This is, when did you get into possession?
In 2022.
2025.
I am in possession. Panchayat is accepted.
There is also, what I find from the sublease, that there is also transaction of amount between the parties. That is, hefty amount is transferred in favor of some party who is granting a sublease in favor of a third party, creating a third party interest over the property without the consent of the panchayat. The petitioner is aware of the fact that the sublease is made in respect of a property belonging to the panchayat.
That is why I made a representation.
When the panchayat has notified, now you place an application. But when the sublease was created, you never filed an application before the panchayat that I am in possession, this has been done, you regularize that.
Or panchayat is accepted a rent towards me, tax towards me. That is kindly
a separate aspect that will be clarified by him. But what is the legality of your possession? A person who is in possession without the authority, can you continue? And asking the court to direct the panchayat to consider his representation.
Kindly appreciate one thing. Kindly see this angle. The person, admittedly, he is in possession of the property which belongs to the panchayat. Now, panchayat has full knowledge with regard to that, my possession. Not only the panchayat, the other authority also full knowledge with regard to my possession. Panchayat is accepted the tax with regard to my possession of the said property. Now, I made a representation. Panchayat could have been rejected.
Had it been the position that you have vacated the possession and participated in the tender process, that would have been a rational approach upon. But getting into possession and asking for a representation to be considered without any authority
with regard to item number 25, your lordship kindly take trouble to item number 24. Kindly see what is their nexus with that property. Kindly come to pair of the writ petition. Kindly take trouble, the pair of the writ petition. By virtue of that writ petition, they wanted to, my lord, converted a writ court to a suit court. They wanted to evict me through my lord without any due process of law. My lord, they wanted to me my lord, direct the authority, direct me to hand over the possession. Well, if your lordship kindly assuming for the sake of argument that I am in illegal possession, then the Panchayat authority should have initiated against steps against me for eviction under the West Bengal Panchayat Act. And your lordship is no, section 6 of the specific relief act specifically says that if a person is in possession of the property, then admittedly is in possession of the property, then he should not be evicted without due process of law. Now kindly see the pair, kindly see this pair. Kindly see the pair of the item number 24. At
25
page
or
number 12,
25,
24, item number 20, page 12,
25 or 24.
item number 24, my lord. My lord, your lordship, WP number 22300. My lord, kindly come to pair, my lord, page 12. Pair A. Pair B, my lord, kindly pair B. A read and or order direction in the nature of mandamus do commending the respondent number 6 and 7 to forthwith the vacate the Sindhu Nivas Lodge come training center. My lord, I am representing the assessment number 7. With regard to 6, my lord, I am not appearing, my lord.
Who is 6?
I am not, 6 is the Samuel Rai, who is the original lease. But I am representing the respondent number 7. My lord, my lord, paid for a mandamus directing me to hand over the possession in favor of him. And which is, my lord, perhaps subject to your lordship correction, is question of eviction, and my lord, without my lord eviction, I am directed to hand over the possession. Well, my first case is that my application with regard to that, my lord, the Pradhan is pending before this court, even before the Pradhan. My lord, I might be a bad person, but my application should be considered whether it is allowed or rejected. Well, they should have called me, no, your PR is rejected, you have been directed to vacate.
You are not a bad person. You are in a possession without authority.
But that should
You
not be
have
kindly
approach the Pradhan. Approach the Gram Panchayat.
Now, kindly see the section
Now
6.
he is a bidder. The other petitioner is a bidder with 25.
But the Panchayat,
He is a successful bidder. He is out of possession. He cannot get into
but the Panchayat without taking any possession, initiated the tender process. When the Panchayat is admittedly, kindly see the representatives, kindly see the demand of justice. Panchayat is admittedly not in possession of the property in respect of which the tender process was initiated. Now, when the Panchayat is failed to vacate the premises by any without due process of law, then when you engage some other person, you run after this person. And kindly see the pair C also, my lord. Pair D.
under which provision this premises belonging to the Panchayat is to be vacated, the steps to be taken. Which is the provision?
My lord, if your lordship kindly considers the
West Bengal Public Premises Unauthorized Occupancy Act 1962.
Which is the provision?
my lord, the SDO is the competent person to approach in case of public premises.
Huh.
My lord, this comes under the Public Premises Act.
Yes.
And if your lordship kindly considers the lease deed that he is relying on, my lord,
First place, the
it is the
public premises, sir.
unpaginated writ petition that has been served, my lord. There it says that he has taken the lease till the expiry of the lease period till 30th of June 2025. It is his agreement that he says. So basically, whatever he is doing beyond that, I don't know, that is beyond this his agreement that he is relying or upon which he is claiming his right.
After 30th June, no right. But how the trade license has been issued in his favor?
Hello, trade license with regard to any person can apply and obtain
No,
a trade
it is
license, my
stated
lord,
Sindhu Nivas.
lordship. That has been granted, I can find from the writ petition, my lord.
You have the act public premises, sir.
Lord, I can get it from the library.
Get it?
My lord, we can come back at 2.
Yes.
Lordship.
Lord, I found the present advocate, item number 20. I am informed that that to be
After this, man. Who is the petition?
Your
Yes, sir.
lordship, I have got the act. May my lord have a look. But this says that you have to approach the collector in case if there is a illegal occupant in any public premises.
What did the panchayat do then?
But you are not in knowledge, my lord. These private
The
persons are
property of a
handling
nature of a hotel being in possession of a third party,
but
you are
thrice
carrying on the
transfer-
business and you are not aware of that.
And my lord, I have informed them, and after they have filed this writ petition, my lord, there is no stay with regard to any tender process that I have initiated after this. My lord, they have specifically prayed for setting aside of the tender notice.
Hmm.
But they haven't moved this writ petition, so basically I am not at fault in proceeding with the tender process. My lord, thrice they have changed hands. My lord, in between themselves. And they have been earning huge amounts of money by way of this conduct, and my lord, the panchayat is the ultimate loser.
But if you are not
But
aware,
this
then you are losing.
entire activity all are illegal.
Owner means
Nothing can be, my lord, they cannot explain these activities, my lord, this sublease or subletting out, my lord, these things are beyond this original tender or original lease agreement that was entered into between that Shamol Roy and the panchayat.
officer, owner of the public land. Yes, you are the successful bidder.
My lord kindly considers one aspect, my lord. My learned senior friend here, my lord, finds that 2022 he is my lord in position. Now, my lord, based on some lease deed. Now, my lord, section 17 of Registration Act, my lord, specifically states lease deed either from year to year or my lord exceeding 1 year. That has to be mandatorily registered. My lord, based on some notarized document, they are claiming possession since 22. So this itself, my lord, and which is my lord beyond the scope of the original lease agreement. But entirely, my lord, this conduct, my lord, is entirely illegal. My lord, kindly, my lord,
Original lease agreement, who has annexed? You have annexed.
my lord, no, my lord, my lord, I am not in my lord possession of that agreement, my lord. My lord, in the other
This
petition, my
was
lord.
the original agreement that was executed between the Shamol Roy and
Panchayat.
panchayat. My lord, after that they have and kept on handing over the possessions, my lord. Those are annexed to his writ petition. And this agreement prohibits them from subleasing.
Which clause?
My lord, may I mark it?
May I get a copy of this one of lease agreement?
With 3 core. Whatever done to the contrary is illegal, my lord.
And well, may I just, my lord, point it out with regard to their writ petition, my lord, with regard to their writ petition, my lord. Your lordship has, my lord, the WB number 222300. My lord, this writ petition, my lord, they have, my lord, fully knowledge with regard to my position. Your lordship kindly take travel to, my lord, the representation that is at, my lord, page 23.
Their being aware or unaware will not make your possession authorized one. Right.
Their pair is my lord. Your lordship, I have my lord seen your lordship, my lord, the earlier question.
With আসুন তো।
My lord, and the document, my lord,
Only one aspect. My lord, kindly considers my lord the plight of my lord the second bit petitioner. My lord, he
Ashok.
was supposed to be handed over the
but
position
the
in June.
That is the your affidavit service.
I filed with your service.
And the other one?
My lord, may I just give a copy of the my lord, document, my lord, which is handed over before your lordship, my lord?
Both the writ petitions are taken up together since there is commonality in the facts pleaded. Affidavits of service filed on behalf of the petitioners in the respective writ petitions are taken on record. By the writ petition being number WPA 13472 of 2025, the petitioner seeks for consideration of his representation dated 9 June 2025, annexure P7. By the writ petition 22300 2025, the petitioners seek for giving effect to agreement dated 23rd June 2025 executed between the petitioner and the panchayat. Panchayat. Respondent number 4. प्रधान पंचायत पार्टी नहीं है between Talgachari 2 Gram Panchayat. The petitioner and Talgachari 2 Gram Panchayat. Respondent প্রধান আছে give the petition. তালগাছড়ি 2 তোকে পার্টি করে প্রধানকে পার্টি আচ্ছা প্রধানই এক্সিকিউট করেছে রেসপন্ড নাম্বার আছে 4 প্রধান তালগাছড়ি 2 গ্রাম and for vacating of Sindhu Nivas Lodge cum Training Center by respond number 6 and 7. The petitioner in WPA ageta contains that by dint of a lease deed, sublease deed, dated 27th September 2024, he is in possession of the property in question, namely where it is where is the specification of the property?
My lord, it is at page 5, running page 5 of the agreement.
Page 30 of the writ petition. Page 30.
Mine is
Within
unpaginated, so my lord, I cannot.
কি বললো property
He is in possession of the
Property.
in question.
question being a hotel cum lodge comprised within Dag number 855 by 1, a Pakka guest house building, comma, jail number 85, Mouja Bilamuri, district PS Digha, district Purbo Medinipur. The lease period is going to expire on 30th June 2025. The petitioner made a representation for extension of the lease period, which has not been considered, hence this writ petition. Extension of the lease. In WP 22300/2025, the petitioner contains that he is a successful bidder in respect of notification of lease dated 11th June 2025, floated by Talgachari 2 Gram Panchayat. However, till date, the possession of the property in question has not been handed over to the petitioner. Being agreed by such circumstances, the petitioner is, or you have paid the money,
Yes, increment.
and petitioner has deposited the entire bid amount of rupees 20 lakhs 501.
20 lakhs 501.
20 lakhs 501.
Being agreed by such circumstances.
Approach this court by way of a writ petition. Mr. So-and-so, learned advocate for the petition in WPA 13472 of 2025, submits that the petitioner is in possession of this property in question and has been running the hotel cum lodge by dint of a sublease agreement, and also upon payment of upon payment of amount. What is this amount? This is called trade license you have given. This is what amount is this called?
Trade license.
Yes, page 35.
Yes.
Page 35, it is 750, my lord.
750. What is this amount called? Under which head this is deposited? He has been ki bola?
A license fee, actually.
Submit
Date of sublease agreement.
Trade license.
License.
payment of
Am I-
license fee. He is carrying on the business. He seeks for consideration of the representation of the petitioner dated 9th June 2023. On the contrary, Mr. Diptiman Banerjee. Diptiman Banerjee. Sorry. Diptiman Banerjee, learned advocate for the petitioner in 22300/2025, submits that as per the notice inviting for the lease, the petitioner has quoted the maximum bid amount, and he is a successful bidder who has already deposited the bid amount. Despite such compliance, the petitioner is yet to get the vacant peaceful possession of the leased property. The petitioner is incurring loss due to such action on the part of the respondent authorities. Learned advocate, Mr. So-and-so, learned advocate representing the Pradhan Talgachari 2 Gram Panchayat, Ramnagar 1 Development Block, submit that there is no such lease agreement executed between the Panchayat and the petitioner in WPA 13472 of 2025. The lease was executed with one Shamol Roy. Top, the lease agreement, the original lease agreement debars the party from leasing the property in favor of a third party. Therefore, the position of the petitioner in WPA 13472 of 2025 is illegal and unauthorized. Paragraph. It is not in dispute that no such lease agreement has been executed between the petitioner in WPA 13472 of 2025 with the Talgachari 2 Gram Panchayat. The petitioner claims his possession through a sublease, deed of sublease, dated 27 September 2024. Needless to mention that the original agreement produced by the learned advocate representing the panchayat shows that the clauses of the agreement debars a person from subleasing the property. Save and except the trade license at page 35 of the writ petition, there are no other documents of showing authorized possession of the petitioner. Such being the position, the prayer of the petitioner seeking for consideration for extension of his lease agreement falls short of merit. Lease period, sorry, agreement, lease period, falls short of merit. Accordingly, the writ petition being number WPA 13472 of 2025 stands dismissed. The writ petition being WPA 2230 of 2025 is disposed of, directing the respondent Talgachari 2 Gram Panchayat. Respond number 4. To take appropriate steps in terms of Section 3 of the Public Land Eviction of Unauthorized Occupants Act. No. Okay, direction the. How long will it take to hand over that? 30 days daily.
My lord, I have instruction, my lord, I have filed already a suit. I have filed already a title suit, my lord, with regard to, my lord, that, my lord. The suit, my lord, is pending before the, my lord, the district court, my lord.
Within 30 days, you can hand over.
The proceeding, my lord, paragraph subject to a correction, my lord. This proceeding is not applicable in respect of, my lord, the public.
Petitioner in WPA 13472 of 2025 is directed to hand over the possession to the Gram Panchayat. It will respond number 4.
Then, my lord, my suit is going to, in fact,
within a period of না এটা 4 হবে না গো, এর এতে 6 হয়ে যাচ্ছে, আপনি নাম দিয়ে দিন প্রধান তালগাছাড়ি 2 গ্রাম পঞ্চায়েত within a period of 30 days করে দিন, failing which the local gram panchayat, namely Talgachari 2 gram panchayat, Ramnagar 1 development block, shall take appropriate steps in accordance with section 3 of the Public Land Eviction of Unauthorized Occupants Act. Upon such steps being taken by the gram panchayat under section 3, the collector shall take consequential steps as required under the Act. With the aforesaid directions, writ petition being number WP 13472 of 2025 and ওই নাম্বারটা দিয়ে দেবেন একটা তো ডিসমিসড হয়ে গেছে
And deeply obliged.
গিভ ইওর নেম
My lord, instead of mentioning the collector, my lord, the appropriate authority may be
Because my lord, subsequently, my lord, the SDO has been, my lord, the
তাহলে অ্যাপ্রোপ্রিয়েট অথরিটি করে দিন বাট দি এসডিও উইল এক্সারসাইজ হিজ পাওয়ার্স থ্রু দি কালেক্টর ইটসেলফ
my lord, under my lord, the SDO has been, my lord, delegated the power, my lord.
Oh.
My lord, section.
অ্যাপ্রোপ্রিয়েট অথরিটি
Appropriate.
Your Lordship, one humble prayer, Your Lordship. There are certain things which I am representing the respondent number 6 in item 24. There are certain objects like electrical fans, chargers, which are still lying in the lodge, which is being run by the petitioner in item 23. If they can be handed over to me, I have such receiving document from the panchayat itself.
the Gram Panchayat upon receiving upon delivery of possession or eviction of the petitioner in WPA 13472 of 2025, whichever is earlier, is directed to hand over the fixtures such as fans. What are there?
Your Lordship, there are certain AC sets, LED lights, ceiling fans, dining table.
Fixtures, namely fans, lights, and other items to respondent. Your respond number 6
Item number 24, Your Lordship, WPA 2230.
to respond number 6 in WPA 22300 of 2025. Upon proper endorsement, direction. ঠিক আছে? Dispose.
And may I get a copy of the, my lord, the agreement, my lord? We have been produced before Your Lordship.
Why?
They have produced a document, my lord, that was not enough. If Your
The
Lordship,
person who has made a sublease to you, you had asked him to give a copy of the agreement.
and deeply obliged.
For order.
number 1.
One lordship, I am acting for the petitioner, madam. This petition, madam, I have challenged the order of
Which one?
item 1, lordship. And in this writ petition, lordship, I have challenged the order of the additional district magistrate and the additional
Lord, I appear for private respondent number 7. I file my affidavit in opposition. Lord, I have served the copy.
objecting. My
I
lord,
have served the copy.
my lord, objecting. There is no direction of the affidavit in a part.
No,
For
give
filing
direction.
affidavit
Because there
in
was
opposition,
suppression,
my
my lord. Cross suppression. That is why that will be disclosed.
And let the matter be heard. If your lordship kindly please to direct the to file the affidavit in opposition, they will certainly file the affidavit in opposition. Lordship, kindly allow me to place the case first. Then, if your lordship kindly thinks fit that the opposition is required to be my lord taken into consideration, he will file and I will file the reply, lordship. Lordship kindly comes to the my lord, order of the additional district magistrate and additional executive officer, my lord, has directing the subdivisional officer Barashot for demolition of the alleged deviation of the building of the petitioner. Now, my
Where
lord,
is that order?
lordship,
Where is the order?
my lord, lordship kindly comes to P8, page 40-41. Lordship, 41 is the relevant page and 42 is the order of the additional district magistrate and additional district executive officer.
15th September.
15th September. Lordship has got it. Lordship kindly comes to page 41.
Yes.
Lordship kindly comes to the middle part of the page. The order of P&RD department. Lordship has got this. My lord, I am reading. The order of P&RD department, government of West Bengal, white number such and such, my lord, dated 29/3/2018. This is a notification which they have relied, has also been found relevant in this case. The serial number 9 of the said order states that whether any new structure or new building or any addition to any structure or building is being or has been erected or made, as the case may be, in contravention of the provision of the West Bengal Panchayat Act 1973 as amended in the West Bengal Panchayat Amendment Act 2017, that is also there with me, my lord. The permission granting authority, lordship kindly see, the permission granting authority shall refer the matter to the subdivisional officer concerned, who may, after giving the owner of such building an opportunity of being heard, make an order directing the demolitions of the building or a portion of the building as the case may be. So, lordship, from this lordship, we have, my lord, your lordships will see, they have relying a notification that is dated 29 March 2018. 29 March 2018. Lordship,
Yes, yes, continue.
29 March 2018, where that notification says that the permission granting authority will refer the case to the subdivisional officer, who, after giving opportunity of hearing to the owner of the building, will take decisions of the demolition. So, my lord, who is the authority to take decision for the demolition is the subdivisional officer. Here, lordship, now lordship kindly skip the next paragraph, and thereafter lordship kindly comes, upon hearing both petitioner and respondent, and based upon the documents and inspection reports submitted, as well as the order of PNRD Government of West Bengal dated 29/3/2018, in the capacity of the additional district magistrate, additional executive officer, North Chobbish Pargana Jilla Parishad, he is the permission granting authority. Hereby refer the matter to the subdivisional officer Barasat, North Chobbish Pargana, with a direction, lordship, kindly take a note of this, with a direction to issue an order directing the demolitions of the deviated portion. So, my lord, the permission granting authority, although relying on the notification dated 29/3/2018, where the notification has stated the permission granting authority is the only authority who referred the matter to the subdivisional officer for demolition. But here, my lord, the permission granting authority referred the matter to the subdivisional officer with a direction for demolition. So, my lord, it is predetermined, it has been, my lord, already decided by the permission granting authority to demolish. Although the notification says the subdivision officer will take the decision whether the alleged building will be demolished or not.
Additional district magistrate Panchayat is the permission granting authority.
Yes, your lordship.
Lordship, I am appearing for the respondent number
So,
2.
here the order or demolition has to, if there is at all deviation, that decision has to be taken by the subdivisional officer. Now, lordship kindly comes to the order of the subdivisional officer. Lordship kindly comes to page 44 and 45. Lordship kindly comes to the 45 last paragraph. Lordship, the order dated 14th March 2024. Lordship kindly comes to the last paragraph, that is in page 45. Now, as per direction given in the proceeding dated 15/9/2023, that one, my lord, by the additional district magistrate, North Chobbish Pargana, and additional executive officer, North Chobbish Pargana Jilla Parishad, I, Somara Sachansar, hereby order directing the owners of the building to demolish. Lordship kindly comes the first line, now as per the direction of the Jilla Parishad. So, it has been decided already by the Jilla Parishad. Thereafter, Jilla Parishad referred the matter to the subdivisional officer. The subdivisional officer has already executive authority. Is the authority for execution. Although, my lord, the notification says the subdivisional officer is the authority to take the decision whether demolition has to be done or not. Here, the subdivisional officer is, my lord, following the order already passed by the Jilla Parishad. So, Jilla Parishad is not the authority to direct the subdivisional officer for demolition. Subdivisional officer independently will take decisions after giving the opportunity whether the building has to be demolished or not. So, my lord, the order of demolition passed by the Jilla Parishad, the Jilla Parishad has no jurisdiction. He is only the permission granting authority to refer the matter to the subdivision. Now, Lordship kindly comes to the Amendment Act of 2017. Copy the five. This is the Amendment Act, my lord, based on which that notification has been issued. Lordship kindly comes the last paragraph. Here, my lord, section 114A, my lord, is amended and inserted. Lordship kindly comes to the last paragraph 5. Para 5. Lordship has got it. Last paragraph. Where any new structure or new building or any addition to any structure or building is being or has been erected or made, as the case may be, in contravention of the provision of subsection 1, the Panchayat Samiti shall refer the matter, in my case, Jilla Parishad, shall refer the matter to the subdivisional officer concerned, who may, after giving the owner of such building an opportunity of being heard, make an order directing the demolition of the building of a portion of the building, as the case may be, by the owner within such period. So, my lord, what is there? My lord, the subdivisional officer will take the decision whether the building has to be demolished or not, and that my lord, refer only the Jilla Parishad or the Panchayat Samiti are the authority to refer the matter to the subdivision. In my case, my lord, the Jilla Parishad has already taken decision. No, this has to be demolished, and there are
Your case is Jilla Parishad, Panchayat Samiti, Panchayat what?
my lord, Jilla Parishad. In my case, it is Jilla Parishad.
Jilla Parishad, then 114B will not apply.
No, my lord. Lordship, why I am saying so, my lord, the lordship kindly comes once again to the impugned order, page 41. The middle part, my lord. My lord, the notification that is
At the very initiation, I asked you who is the permission granting authority in your case?
permission.
Jilla Parishad. Then 114 will not apply.
Yes. The Jilla Parishad was reliant upon the notification dated 29 March 2018. The 29 March 2018 notification has stated, my lord, the serial number 9 of the said order. Said order means that order dated 29 March 2018. States that where any new structure or new building or any addition to any structure or building is being or has been erected or made, as the case may be, in contraventions of the provisions of the West Bengal Panchayat Act, as amended West Bengal Panchayat Amendment Act 2017, the permission granting authority shall refer the matter to the subdivisional officer concerned, who may after giving the owner of the building an opportunity of being heard, make an order directing for the demolition. So the subdivisional officer will take the decision independently after giving opportunity of hearing whether the demolition has to be done or not. Here the subdivisional officer is complying, is abiding the order already made by the permission granting authority. Now, lordship kindly comes, lordship, after filing my lord, lastly, lastly, my lord, I have received the memo of the block development officer, my lord.
May I submit one thing, lordship?
My lord, here, my lord, they have
Who is
stated
the permission granting authority in your case?
Jilla Parishad is the word.
Then you are guided by 160A.
Lordship kindly comes to their own notification.
Which not?
They are relying on that. My lord,
Can rely on many things, but you are here to submit the legal provisions. how the additional district magistrate has proceeded to pass order.
My lord, the oppositions, my lord, they are which they were intending to file. My lord, their lordships, the notifications is annexed. Lordship kindly comes.
This is the plan.
This is that notification, lordship. My lord, my lord, the sanction building plan, I have converted the land.
You have deviated.
But my lord, thereafter this construction has been made.
Continue operation করতে গেল। So it is not Jila Parishad, it is Gram Panchayat.
Subsequently, lordship, when the my lord, when the square feet has been my lord increased, then the Jila Parishad has come to the picture, lordship.
So where is that?
My lord, that is my lord. Page 31. Like that. Page 31, lordship. Lordship, kindly see this plan has been reviewed by the Jila Parishad. Because my lord, the square feet has been increased, so my lord, it will come within my lord under the Jila Parishad.
It will go back.
Executive officer,
Panchayat.
the notification says whoever is the permission granting authority, his function is only to refer the matter to the subdivisional officer.
He has to also come to a finding that there is contravention.
My lord, lordship kindly comes to the my lord, the opposition which they are intending to file, page 51 of the opposition. The
Okay,
notice.
file them the original lordship. He's relying the copy. I have the original lordship.
Lordship, in this opposition, my lord, there is no direction from your lordship to file the opposition.
এখন নেব না।
Lordship, I just want to draw your lordship's attention with regard to the order dated 29 March 2018, page 50, lordship kindly comes. Since it is there, that is why lordship. Page 50, 51, lordship kindly comes. Paragraph 9. Their impugned order, my lord, they have, my lord, referred this paragraph 9 of this order. Yes, my lord. Impugned order, this paragraph 9 of this order.
Where
Page
is the earlier
51,
order?
lordship kindly comes to page 51.
Where is the earlier order?
Earlier order, my lordship.
Earlier writ petition.
Yes, lord. Earlier writ petition, my lord. I have annexed everything, lordship, in my petition. Lordship kindly comes to page 22. 32, lordship. 32. This is the mandam order of the Honorable Division Bench. Because, my lord, the order which has been, my lord, passed by the Honorable Single Bench, that has been challenged by the petitioner, and this is the order of the Honorable Division Bench. Lordship kindly comes to page 33. The order of the Honorable Single Bench was set aside, and it was sent for reading, hearing, and, my lord, afresh to the Honorable.
After that,
lordship kindly comes to page 35 is the order of the Honorable Single Bench, my lord, deciding the issue afresh. Lordship kindly comes to the page 38. My lord, directing the authority to conduct the inspection, to take decision, giving opportunity of hearing to all the parties. My lord, That is the and to my lord pass the necessary order. This is the my lord the order which says in the single bench judgment, my lord. Honorable single bench judgment. Page 38. Hereafter, lordship, my lord, the permission granting authority passed the order of demolition and directed the STO to demolish. And
See,
relying on a notification.
first of all, your permission granting authority is the Samiti or the Jila Parishad.
My lord,
If it is Jila Parishad, then the state has to appoint a hearing officer to conduct the hearing. The additional district magistrate has no authority. Thereafter, the matter will be referred to the subdivisional officer for demolition or whatever.
my lord,
This is the 160A. But if it is a Panchayat Samiti, as has been quoted, then we have to examine whether the additional district magistrate authorized to pass this order or not.
my lord, lordship will see in the impugned order that order which they relied upon. My lord, the order paragraph
Not understand.
says that they
See.
will only refer the matter to the SDO, and SDO will take decision independently whether the building has to be demolished or not. Lordship, kindly
See, what is in the act is, if there is a contravention, somebody files an application making some allegation that there is deviation or illegal construction. Now, prior to making reference to the SDO, a preliminary inquiry has to be held and find out whether there is contravention or not. Why the complaint will refer to the SDO? Any complaint lodged to the Panchayat,
no, Lordship.
then
That preliminary.
one has to come to this finding that there is certain contravention
Yes,
which necessitates for reference.
yes. My lord, that is.
You
that
can
is-
argue on this issue that direction ought to not have been passed,
Yes, my lord.
but contravention, if there is there, they can refer the matter.
It
Huh?
is done. My inquiry made.
Now the question is whether if it is permission granting authority is the Jila Parishad, then 160A capital A is to be added to. The additional district magistrate cannot take upon himself the responsibility of passing order.
Yes, your lord.
State has to appoint a hearing authority who will hear out the matter thereafter.
Yes, your lordship. I bow down to your lordship. Now, lordship.
But
it
what
comes to
is
the last-
who? I am still not clear who is the sanctioning authority in your case. You have referred to Panchayat Samiti. I find the Jila Parishad has issued the order, and the second sanction plan shows.
Here, my lord, it has been said that my lord, the permission granting authority. So, my lord, the if the Panchayat Samiti is there, my lord, he is also the permission granting authority. The Jila Parishad,
No,
my
no,
lord,
no.
he is also the permission granting authority. My lord, neither the Panchayat Samiti nor the Jila
If it is Jila Parishad, the circumstances changes. Changes in the sense that the hearing officer has to be appointed. If it is Panchayat Samiti, then we have to examine the order passed by the MC. This is the.
Lordship kindly comes to the order, lordship, on 11/9/2025.
Who is for the state?
My lord, the
Yes,
block development officer, this is the last order. Here also, my lord, the BDO has stated in compliance with the order passed by the Jila Parishad. So, my lord, no independent application of mine. Following the order of Jila Parishad, in compliance with the order of the Jila Parishad.
Who will assist? Yes.
Lordship, may I place one thing or just the order passed by the Jila Parishad
Who
was
is the permission granting authority?
here. Lordship, kindly come on the page number 37 of thereby the order passed by Honorable Justice Sampa Sarkar, whereby there was a logical reasoning was there. May I read this? Lordship, may I read this? Page number 37 of the read petition. May I read this, Lordship?
Tell me one thing. I have seen it. Who is the permission granting
It-
authority?
It is stated that if the panchayat authorities upon inspection of the construction come to the conclusion that the height and the plinth of area of the building would require permission waiting from the Jila Parishad, then the entire issue with the preliminary finding shall be sent to the concerned Jila Parishad,
Correct.
which would be permission granting authority. In this case, the height of the building is a 5-story building. So in that case, the Jila Parishad is the permission granting authority, and in compliance of this order passed by the Honorable Justice Sampa Sarkar, the Jila Parishad has passed the decision. After conducting the hearing, that is and submission, Lordship, Jila Parishad cannot pass a decision. Jila Parishad finding, if at all there is some deviation, Jila Parishad after conducting inquiry will send the matter, will refer the matter to subdivisional officer for passing an order of demolitions if the subdivisional officer at all thinks fit. Here, everything has been decided.
Send to the Jila Parishad. Where is the letter of sending the matter to the Jila Parishad? Where is the letter? Is there any communication made by the panchayat to the Jila Parishad?
By the petitioner, Lordship.
Come to page 37.
Page 37.
The panchayat authorities upon inspection, if it is found that the height is more than the what is required, it will refer the matter. Building would require a waiting from Jila Parishad, then the entire issue of preliminary
Yes,
findings
sir.
shall be sent to Jila Parishad, which would be the permission granting authority. Where is that inspection report?
And even, my lord, I have not been, my lord, served with a copy of this impugned order of the Jila Parishad.
Where is the inspection report?
Lordship, I am appearing for the respondent number 2. I am not for the state, Lordship.
Based upon the documents and inspection reports, as well as RP and RD.
My lord, served upon me. Not the order of the Jila Parishad has been served upon me. My lord, I have straightway directed by the subdivisional officer by its order for demolition. Subsequently, I have come to learn about this order dated 15/9/2023.
So who is
passed by
produced the
Jila
inspection
Parishad.
report?
And it's a gross violations of the principle of natural justice, Lord.
Inspection, where is the inspection report?
That is in my opposition, Milord. They have suppressed that. They were present all along, Milord.
Where is the
During the-
inspection report?
Yes, Milord.
Whom is the inspection report? Of the panchayat.
No, not Panchayat, Milord. This is, Milord, before the ADM, Milord, respondent number 2. On the date of hearing, Milord, 1st June, Milord, a preliminary report was submitted, Milord, because foresight of deviation was not mentioned. Milord, the authority directed, Milord, by the senior officer, Milord, to conduct inspection. Milord, on 7/6/2023, Milord, inspection was conducted and all were present there, Milord. Milord, I have annexed that, Milord, report. And it is, Milord, it was considered by the authority also.
I don't
Before going
understand.
to that, Milord, may I submit one thing, Lordship?
No,
Milord,
come to page 37.
Lordship, be up there, Milord, up there. Lordship.
If the panchayat authorities, upon inspection of construction, come to the conclusion that the height and the plinth area of the building would require a permission waiting from Jila Parishad, then the entire issue with the preliminary findings shall be sent to the concerned Jila Parishad, which would be the permission granting authority. Now, where is the inspection report of the panchayat?
Milord, that is not with me also, Milord. But, Milord, the fact is stand. Fact is, Milord, which will
Asun.
appear from the inspection report, Milord.
Asun.
Lordship, may I submit one thing, Lordship?
Asun.
Lordship, instead of keeping the pending, Lord, writ petition, Lordship, direct, Milord, the SDO to conduct the hearing afresh, my Lord. No useful purpose will be served, Milord. Lord, submission of my learned friend is that, Milord, SDO is the authority to consider, Milord, and the hearing, Milord, conduct. Lordship, direct the SDO, Milord. Set aside that order of Milord ADML or Milord.
কি হলো?
I am admitting her submission, Milord.
Can you produce any document that the Jila Parishad is a permission granting authority?
Milord, since
Last 10 minutes I am harping on this point. Who is the permission granting?
Milord, neither she could, Milord, neither Milord state, Milord. Milord,
Law changes if the Jila Parishad is a permission granting authority.
my lord, may I submit one thing, Milord? Milord, set aside the order, Milord.
Why?
And Milord, because if your lordships, Milord, find Milord some other section is applicable, lordship will.
How can I come to this conclusion? Because the application of the law changes with the permission granting authority. If it is panchayat, then you have some other provisions. If it is Jila Parishad, then some other.
Milord,
So the court says that you cause an inspection, find out if heading is necessary for the construction, then the permission granting authority will be the Jila Parishad.
total,
If Jila Parishad comes into picture, then it is 160A, then they have to appoint a hearing officer. ADM has got no authority to pass order.
this is the Jilla
Produce that
Parishad, Milord.
inspection report.
Lordship.
Produce that inspection report. If you have, you place that inspection report.
Lordship, because
Then
it is not
everybody will say no.
that.
Then the panchayat has not followed the order that was passed.
My lord, on the contrary, Lordship, this is the order, my lord, where my lord, the block development officer stated in compliance of the order of the ATM, my lord, the demolition will be carried on 19/9/2025. That is tomorrow, Lordship. My lord, I have just
Milord,
one copy. and
It is admitted fact, Milord, because that is why, Milord, all documents were not annexed. That is in my opposition, Milord. And Milord, I respectfully submit, Milord. Set aside the order, Lordship, and Milord, direct Milord SDO or Milord other competent authority to rehear the matter, Milord.
Who is the competent authority?
Milord, according to her, Milord, SDO is the authority who will, Milord, after giving hearing, Milord, pass the order.
Who?
But she says, Milord, SDO, she has submitted so long, Milord, on that point also, only, Milord.
My lord, the order of demolition is the SDO is the authority to pass the
Lordship may also, Milord, set aside the order of demolition, Milord, and Milord, direct the concerned authority to rehear instead of keeping the matter pending, Milord, direct this, Milord.
Ask the block development officer to produce any inspection report conducted in pursuant to the order passed by this honorable court. Take this man.
Lordship, kindly see. My lord, tomorrow is the day.
Milord, nothing is going to happen, Milord. Nothing is going to happen, Lordship.
Going to be assured.
Affidavit of service.
My lord, yes.
আসছে রে, কিছু নেই, মানে আমাদের মানে তিনি সেটাকে ডিসপোজ করবে। 7/6/2023, who conducted the inspection? Seven six 2023.
Order of the in order of the Jila Purishad.
Page number? No, 7/6/2023. It records that there is a deviation. Where is the inspection report?
That inspection report is, my lord, in my opposition, lordship. It is din, sir.
41.
It is din, sir. My lord, that is, my lord. Lordship will find at page 21, lordship. Page 21, where, my lord, did a total, my lord, construction deviation part and, my lord, the sanction part. Towards the bottom, lordship will find, my lord.
Give a copy of 18.
Lordship. Perhaps, sir, my lord.
Page 18. Annexure A. In the middle portion, it says that after checking the records, it is found that it has been approved by the Jila Parishad. So 160A will come. Ashun. Give a copy of this one. This will be. Writ petition. Here you go. Affidavit of service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner seeks for setting aside and or quashing of the order dated 15 September 2023 passed by Additional District Magistrate Panchayat, North 24 Parganas, and Additional Executive Officer and order dated 4 March 2024. ওটা করে দিন, North 24 Pargana Jila Parishad, Additional Executive Officer. And order dated 4th March 2024 passed by Subdivisional Officer, Barasat Sodor. The petitioner contains that the impugned order is bad on the face of it. The Additional District Magistrate Panchayat has passed the impugned order directing the SDO for demolition, which is not in accordance with the provisions of West Bengal Panchayat Act 1973. The subdivisional officer, upon such reference, has to take its own decision upon notice to all the parties. However, the order of the subdivisional officer for demolition has been passed as per the direction issued by the additional district magistrate Panchayat. There is no independent finding of the subdivisional officer in its order dated 14th March 2020. Being agreed by such 14th March, 14th. Being agreed by such orders, the petitioner has filed the present writ petition. Ms. Swanso, learned advocate for the petitioner, referring to section 114, capital A, clause 5, submit that in contravention of the provisions, if any construction is made in contravention of provisions of the Act, the matter has to be referred to the subdivisional officer, who, after giving an opportunity of hearing to the parties, can make an order directing demolition of a building or portion of building as the case may be. However, in the present case, the procedure adopted is not in consonance with the provisions of law. She seeks for setting aside. Learned advocate for appearing for private respondent numbers, career for
For respondent number 7, Lordship.
7.
Would your Lordship
Also submits that the matter
Milord,
be
what
remanded,
document? Because Lordship, take Milord,
matter
no
be
independent
remanded
finding was there.
matter be remanded to the authority for reconsideration. Current advocate for the state also submits in the similar fashion. By order dated, Justice Sarkar's order,
20th, no, the Lordship,
by order
2023.
dated 23rd 20th January 2023, following direction was issued. If এটা লাগিয়ে দিন, পাঠিয়ে দেব, আমি দিচ্ছি। এখান থেকে দাঁড়ান, সবটা নিতে হবে না, এই অবধি করুন, পুরোটা নিতে হবে না, ইয়ে হয়ে যাবে না, এই অবধি করুন, এই অবধি করে দিন। হ্যাঁ, এখান থেকে ছোট করে দিন, অন সাইজ করে এই অবধি করে দিন, ঠিক আছে? হ্যাঁ, হ্যাঁ, ব্যাস। হুম। Upon going through the aforesaid order, it is found that it has been observed by the Honorable Court that in either case the permission granting authority, be it the Panchayat or the Jila Parishad, shall decide the issue by adhering to the following procedures as depicted in the said order as aforesaid. the report of, give that copy, the report of the,
After James, I think, or
give it now, get a copy of that and hand it over to the court officer. Now give it the report of the report. Sir, will you kindly hand over that? Let me go through that page of the assistant engineer's report. Thereafter, whatever you like to do. No. The report of the executive engineer dated 26th April 2023 record that after careful checking of official records, it was found that the plan for G plus 4-story residential cum commercial building was approved by the Jila Parishad VDA approval order number 642/NZP dated 14th October 2020. At this stage, it will be opposite to reproduce section 160 capital A 5. 5 of the West Bengal Panchayat Act 1973. ছোট বইটা নিলেও হয়ে যাবে ওখান থেকে কোড করে দেবেন, ঠিক আছে? আচ্ছা 6টা করবে। 6 upon the aforesaid provision manifests that in case of contravention of subsection 1, the matter shall be heard by a hearing officer who shall preferably be a retired senior government officer with the experience of having worked as a magistrate and shall be appointed in the Jila Parishad by the state government. In the present case at hand, the order of demolition at the first instance has been passed by the additional district magistrate Panchayat and additional executive officer of the Jila Parishad. There is no such order of appointing any hearing officer as required under section 160 capital A. Such being the position, the orders passed by the additional district magistrate and consequential orders by the subdivisional officer is short of authority as provided under the Act. Accordingly, both the orders are set aside. The Jila Parishad is directed to decide the issue following the procedure as laid down in the order dated 20th January 2023 WPA 13050 of 2019 upon appointing a hearing officer and take the matter to the logical conclusion within a period of 6 weeks from date of communication of the order. Give a copy of this.
I've given losses.
এটা কি দিয়েছে একটা দিয়ে দাও, এটা রিটার্ন করো। কোনটা কি অর্ডার সে আছে দাও,
কাগজ দিন না।
My lord, one October matter is
Generation.
Item number 21.
item number 19. October.
21 is your matter. Can you take up tomorrow? Where is the learned advocate for the state?
Lordship, Vipal Kumar Sai is appearing virtual for 21.
Tomorrow I'll take it up.
All right.
We calculate around the 21 টাই দেবনাথ বাবু 21 কালকে
19 October.
19 19 টা compassionate আছে
Tuesday or Wednesday. I have some
দেখি কি আছে যদি পড়া তো 2 মিনিটে হয়ে যাবে
all good after vacation as you lordship.
19 what is the report?
Lord, I have related application, Lord, that's why it has been rejected. But I filed a report if they have filed exception to my report.
আচ্ছা
Kindly either Lord, if your lordship wants to hear this matter Lord, before vacation, then Tuesday or Wednesday, or Lord, otherwise Lord, after vacation, subject to your lordship's kind convenience.
Tuesday
Kindly ask.
I am always here. I am always here. From 2 p.m. I am here Lord, from 2 p.m.
the time is not with us.
Yes.
She was waiting till in the morning yesterday also the matter was called. তাহলে on Tuesday you are not coming? দেখো তো Tuesday তে on the joint prayer of the parties place this matter on Tuesday 23rd. 25 এর matter Tuesday কি ঠিক আছে? Twenty-fourth এর কথা 24th.
Lordship, Lord.
One humble prayer, respect to the matters that are under the head of contempt. Item number 18, applications. But this matter, they have given us a copy of their answer regarding the notice issued. The only thing is that my lord's direction was to, if they find the illegality,
Come
but if the other side finds the illegality, my lord, they will rectify the same. Now, my lord, they have found the illegality. Now, my lord, they had not done anything till date. A contempt has been filed. My lord was pleased to direct a notice to be issued.
who is for this contempt?
Utti or Roy Chaudhuri. Utti or Roy Chaudhuri. Now, my lord, we have put them on notice, my lord. He was here also, my lord.
Have they served a copy of the affidavit of compliance?
No, not yet. But freehand, my lord, they have served as a copy of a letter form of their compliance.
কালকে তো নিব
But tomorrow, my lord, Monday, my lord, because tomorrow I will be not be coming.
then again you have to give a notice that this matter will come up on, otherwise making it not today tomorrow it will come up, or else you have to give a notice.
Oh, actually, he is here.
Just a minute.
18.
18 we are placing it on Monday. এটা 18 টাকে Monday তে করে দাও। Your compliance is ready. Okay.
Monday.
Then they have not given a copy to you?
My lord, a copy has been not in the form of compliance, but a copy has been given, my lord, to her.
See on Monday. ঠিক আছে।
My lord, item number 16, all are present, my lord. My learned friend, my lord, taking time for this.
My lord, item number 16, my lord, Mr. Jayantanarayan Chatterjee is appearing on behalf of the petitioner, my lord. My lord, we have duly prepared the affidavit in reply, but we cannot file it, we cannot affirm it due to the several illness of the petitioner, my lord. Kindly, my lord, keep it on Monday, my lord, we will file. Kindly, my lord, keep it on Monday, my lord.
And my lord, can you fix a time because we have to wait till
Learned advocate for the petitioner seeks accommodation.
all along we are keeping
No.
waiting, my lord.
Petitioner opposite party.
Petitioner.
Petitioner.
And for petitioner.
Applicant seeks accommodation to file affidavit in reply.
My lord, Monday we will file. Duly
No,
filed.
after vacation.
My lord, kindly, my lord, Monday, my lord, kindly, Monday.
That was gone.
Many matters are there.
If it's not Monday, my lord, file it on Monday,
After
my lord.
vacation, 1 week after the vacation, this matter 1 week after the vacation.
Kindly, my lord. Kindly.
16. 1 week after the vacation comes. Chalo. Original side,
Mention করবো? May I have my lord's kind leave to mention item number 7 in today's list, the original site daily list, my lord. My lord, I'm being led by Mr. Srijit Chakraborty. My lord, the matter was taken up and direction was given to file affidavits. My lord, affidavits have been complete. My lord, there's a very short point. My lord, the matter is coming up so below in the list. My lord, if on next week, my lord, precedence, it's a very short point.
next week, original side.
My lord, actually an execution decree of a foreign decree of
subject to the leave of the court. Item number 35. Lordship has heard the matter in detail. Huh? Milord, this is my appellate side. Milord.
original site.
Original side lead. Chalo.
My lord, if some precedence can you...
Sir, I cannot.
My lord, under precarious circumstances, my lord, may I be permitted to mention, my lord, under precarious circumstances, may I be permitted to mention item number 6 of your lordship's list, my lord, it is that Charushila matter. My lord, kindly appreciate, my lord, the receiver is not functioning, my lord. Even the court has, my lord, directed to stop the bank account operation by the receiver, my lord. How would the trust run, my lord? Unless there is an order, my lord, suitable direction.
Okay. Let's see, go serially. To be mentioned.
Well, I had mentioned this matter.
এটা কম্পিউটার এটা ঠিক করছে না বারবার এটা নষ্ট হয়ে গেছে কি করবো You have a copy of the order?
Well, this is the copy of the order passed in the suit. সেটা আমি আনি
matter নেবে
Well, this was passed on 17th September 2024, my lord. 17th September 24.
17th September.
My lord.
So the decree was passed in appeal.
My lord, decree was passed in appeal. This is the copy of the decree, my lord. And this, my lord, was dismissed, my lord, by Honorable Justice then, my lord, Justice Padma Kastaki.
What is the order passed in the suit?
Well, a suit, but the plaint was rejected, my lord.
Oh, where is that order?
The plaint was taken off file, my lord.
T2. এই কপিটা কি প্রডিউস করেছে টাইটেল সুটের What happened in the appeal?
My lord, in the appeal, my lord, the appeal was decreed, my lord, on a consent decree, my lord. Well, this is the decree, my lord, that is passed in appeal. My lord, says page 2, of the decree. Page 2, my lord, of the judgment. My lord, it mentions about the suit, my lord. Copy here.
এই অঞ্জন বাবু এটার বেসিসে কি অর্ডার করলো বলে রিকল করলো এই অর্ডারটাকে রিকল করতে রিপোর্ট করে দিন কি অলরেডি judgment passed in appeal. This matter is appearing under the heading to be mentioned. This Rituparna Ghosh, learned advocate, appearing for the plaintiff.
From the defendant number 1.
Defendant number 1 submits that initially the plaint was rejected in
July 3rd, 1992.
by order dated 3rd July 1992. The said order was assailed in APO 504 of 1992.
And 505. 2 appeals, my lord.
555.
555 and 504.
No, 555 of 1995. In the
Of 1992.
one is of 92, another is of 95.
Well, both of 92, my lord. Well, there is a mistype, my lord, in the memo of appeal.
এটা আবার কোত্থেকে ঠিক করবো এই নাম্বারটা ভুল আছে উনি বলছেন এটা 92 হবে
92 তো দোনো
ওটা নেক্সট নাম্বারটা কেটে দিন and one other appeal. In the appeal, decree was passed on compromise. However, the suit came up before this court on 17 September 2024, wherein an order of 4, wherein an order of dismissal for default has been recorded. She seeks for appropriate orders. In view of the above submissions, the order of dismissal for default dated 17 September 2024 is recalled. Learned registrar original side is directed to note of disposal in the register কি আছে register কোন register নোট করেন suit register না suit register in the suit register. So this will be recorded as disposed.
Only one humble submission, my lord. This was a decree on consent, my lord.
Decree on consent, not compromise. Decree on consent, compromise.
Much obliged.
You have this copy, we give a copy of this.
My lord, I leave it with the records, my lord.
Number 2.
Much obliged.
Next week original check রাখবেন না next week original check রাখবেন Non-application notice কি কিছু দিয়েছে? Non-appears on behalf of the parties. This matter is appearing under the to mention non-appears on behalf of the parties. Peruse the report of master and official referee original side High Court referee original side High Court Calcutta dated 17 September 2025. By on 19 December 2024, leave was granted to draw up and complete the decree mentioned in the application. Upon perusal of the report, aforesaid report, following discrepancies has been noted. এখান থেকে করে দেবেন 1, 2, 3. আমি একটা ফ্ল্যাগ লাগিয়ে দিলাম, হ্যাঁ? 1, 2, 3 দেখি পেছনে কিছু আছে না। 1, 2, 3. In view of the above discrepancy as noted in the report, the leave granted on 19 December 2024 is withdrawn. The applicant is directed to remove the discrepancies as noted in the report. আচ্ছা, এটা এই ডিরেকশন দিচ্ছি না, ডিটারমিনেশন তো নেই। লিভটা উইথড্র করে let the matter be placed before the appropriate bench having determination. ওটা উপরে নোট করো।
My lord, I beg to appear on behalf of the my lord. Caveator son. Are এটা দেনা। ওটা। Like it was the contention of the my lord propounder petitioner that we have challenged the title, so we lost our locus standi to my lord to file affidavit in support. There is no my lord dispute in that proposition of law that probate court does not decide any title, so nobody can challenge the title. My lord, from my my lord affidavit in support of caveat, my lord, they have referred few paragraphs, few lines of some paragraphs. They referred, my lord, para 7 subpara B.
In which paragraph of the application?
Not application, my lord. They have, my lord, the affidavit in support of caveat.
কিন্তু affidavit in support of caveat.
তোদের কপিটা দে না, মার্ক করা তো স্যার দিন, তাতে কি হয়েছে?
It's my marked copy আছে।
অরিজিনাল ফাইলটা এসছে, পিএলএফ ফাইলটা এসছে, দেখো তাহলে এতে থাকবে নোটারিয়াল করা। হ্যাঁ, ওইটি
Thank you.
টেস্ট 3 প্যারা 7 সাব প্যারা বি, দে রেফার্ড। I'll got it. We said, my lord, that my family belongs to a Hindu Kshatriya family governed under the Mitrasara school of law. As such, the interest in the family properties shall devolve by survivorship upon the surviving members of the co-personary. They, my lord, want to say, my lord, by referring this, we are challenging the title. There is no semblance, my lord, that by this it can be presumed that we are challenging the title. Next page, my lord. Next paragraph, my lord. They say, my lord, again we have repeated, my lord, Mitaksara school. So they, my lord, try to say that by this saying we are trying to, my lord, oppose the title of the testatrix, which is not, because the next paragraph, para C, my lord, next page, page 4, we say, my lord, few lines from the bottom, the word starts from the that apart. My lord, got it?
That about, yes.
That apart. That apart, my mother, Chhaya Rai Chaudhary, had sufficient rental income received from the property at 52H Beni Satansa Street, Kolkata, as well as monthly interest received from the substantial deposit in various banks. Well, unless my mother was the owner or is the owner of the particular property, she could not have, my lord, have the rented income. So we admit that she was owner, she was getting rented income. For what reason we had said this, my lord, that is the, my lord, we may disclose at the time of trial, because these are the things, because we have been totally excluded from the property. With the saying that we are, the mother was unable to look after her. These are the things. I will not go into that questions now, my lord, because we raised, my lord, suspicious circumstances, and my lord, this is not a free will. Son, only son, and only sole surgeries. My lord can understand what context we have said this. I need not to disclose, my lord, go into any further. Para D, they referred. We also relied the, my lord, compromise degree of the partition suit of the entire property. We have annexed the decree. My lord, last line of para D. And thereby my father, I and my father were jointly declared to have 1/3 interest in the suit property. By saying that, my lord, by referring this line, they are trying to establish that we have challenged this, my lord, the title. It is not. Next para. During pendency, since father died, mother was, my lord, substituted. And my lord, next para, my lord, para F. May I read? In the said suit, a final degree was passed on 16/8/2003 in terms of the compromise among the co-signers, since the said suit was decreed on the basis of the terms of the compromise, irrespective of the fact whether my child was a necessary party in the said partition suit or not, under the Mitaksara school of Hindu law. However, she had opted for the guardianship of the caveator herein, who was minor at that point of time, under the Mitaksara school of Hindu law, under Indian Succession Act, Hindu Succession Act. She was allotted premises number 52H Beni. Beni London. Yes.
সুইচগুলো আছে দেখো, দেখে ওগুলো চেঞ্জ করে দেবো।
Well, I'm referring paragraph F, my lord, subparagraph F, last 3 lines. She was allotted premises number 52H Benin Nandon Street, P1 Post Office, Bhawanipur, Kolkata 25, on the basis of the said compromise degree. So we accepted the compromise degree, and the share allotted to my mother accepted. And this is the property in the affidavit of asset, including other property. So question of challenging the, my lord, the title of my mother does not ever arise. And in several paragraphs, each and every paragraph, my lord, will find that we said, my lord, mother's property, mother's residence.
But she was allotted, she was not a party in the partition suit.
She was not, because it was father's property. Subsequently, she was, my lord,
Implemented.
yes, implemented. Yes.
Yes.
And my lord will find para G. They referred saying that this is my, they tried to say that I said this is my property was allotted to my mother by referring the last few lines of paragraph G. They tried to say, my lord, thereby by making provision in the said compromise degree, the said residence situated at 52H Benibandhan Street, such and such, was allotted to my mother out of my 1/3 share in the said partition. So it has been allotted. Even assume it was to be, for the sake of argument, it was not to be allotted. It was allotted. They accept. So degree accepted. Compromise degree accepted. What remains? I cannot challenge my title. And not only that, and for what reasons, what context I have said, next paragraph, my lord will find, my lord, my mother was allotted 56 lakhs rupees. Para H. In what context, my lord? I once again repeat, my lord, I need not to disclose all this for the, my lord, to disclose this argument, my lord, at the appropriate time. When the questions would be raised, would be asked on the basis of this averments. If my lord find the will, text of the will, my lord will understand for what reason I have said this. I need not to go into this, my lord, disputes now.
Yes.
In each and every paragraph, paragraph H, J, my lord will find there is sentence line that the ancestors' properties were kept at the residence of my mother. Para J, middle portion, of my mother, residence of my mother, at such and such address. For what reason I have said the ornaments and everything and these things, articles, were kept in the office, in the house of my mother, that I will, my lord, in the appropriate time, I will, my lord, submit and argue, my lord. By this reason, my lord, they cannot say that I have challenged my mother's title. It cannot be. Because each and every paragraph, each and every line, I say it is my mother's residence, my mother's property. She was allotted the property. So there is no, my lord, question, or there is a semblance of evidence, out of evidence, in the, my lord, my affidavit in support of caveat, that I have challenged my mother's title. And my lord can record that even we are not challenging the title of my mother. Because if I have to challenge the title of my mother, I have to file an independent suit, which I never did.
But then how do you interpret that his share was allotted to his mother? He says,
yes,
out of my share. So
yes,
mother's share was not there in the property.
Initially not there. As per Mitheswara school, my lord knows. But however, it was allotted. I accept it. Decree was passed. Everybody accepted this proposition, whatever the decree is, and on the following of that, my lord, we are accepting that. We are following that. I never claimed that it is my property.
As per the affidavit of assets, this is the only property. 50.
The other properties are also. Another property is there. Another property is there. Para Q, my lord, page 8. That on Ato, most unfortunately, my mother being Para Q, my lord, page 8. My lord, para Q. On March 26, 2020, most unfortunately, my mother, being the deceased above named, died at her said premises. Next para R. After cremation of my mother, I went returned to my mother's said residence. Even paragraph R last line, my could not attend and said premises such and such, or after my mother's death or the lockdown prevailing at the time, I could not go. So everywhere, my lord, I said, my lord, it is my mother's premises. Para S, para 9, page 9, first line. When on 1st June 2020, unlock 1 commenced, I went to my mother's said residence at such and such. Paragraph T, third line, to my mother's said premises. My lord, got it? So each and every paragraph, my lord, will find that I never challenged, even impliedly, any title of my mother. And my lord, take from me that we are not challenging the title of my mother. So the entire argument and the pleadings, my lord, and the judgment refers by the propounder regarding question of title raised by the party in a probate proceeding does not arise at all. And not only that, before filing this GA6, they have filed an application GA3 seeking the probate petition, probate proceedings into testamentary suit. Keeping pending this application, now they have come up with an application with GA6 saying that to discharge the caveat on this ground. It is not permissible. Because my lord knows on limited ground, my lord, a caveat, well, whether the caveatable interest is there or not, can be challenged because I am a son. In absence, in intestacy, my lord, of the testatrix, I would be the sole beneficiary because I am the sole heir, no other heir.
Who is the applicant?
No, I.
Applicant in PLA.
Applicant is the brother of the
Maternal uncle.
maternal uncle. My lord, understand. Now, my lord, understand. Everything from maternal's property, petitioner got. Everything from my mother's property, now trying to, my lord. Why they afraid of, my lord, to prove the will in contest, my lord? I don't know, my lord. For what reason they are filing this application? Because his son cannot be excluded as, my lord, not having interest, caveatable interest. A son cannot be, my lord, excluded.
That's all?
That's all. And for what reason, my lord? Once again, I repeat, my lord, for what reason and what context, my lord? This, my lord, the statement my learned friend referred, showing that I have challenged my mother's title, that I will not disclose at this time, my lord. My lord can record my submission that we are not challenging the title of the testator, testatrix. Let them place GA3 for converting the testamentary suit, keeping the pending the first application They are now coming up with an GS6. I don't know, my lord, whether previous order was there to file, my lord, the court fees. I don't know whether it has been.
That has been paid. That has been paid, Your Lordship. The ad valorem court of 50,000 has been paid.
That is ad valorem duty, stamp duty.
Stamp duty
It's
or court
not
fees also
court
paid.
fees. Court
Court
fees.
fees also paid. I have the document with me in this file, I guess.
Yes.
If I don't
Do you want to make any reply?
Yes, Your Lordship. Kindly comes to affidavit of support of masters on GS6 application, my application, Your Lordship.
Support of masters.
Yes.
Page 6, Your Lordship. Page 6, paragraph 19. That the applicant states that the testatrix was allotted 52H Bainandon Street for her exclusive use and enjoyment in compromise decree passed in title suit 67 of 1957. And it is salient principle of law is that the compromise decree cannot be challenged in a subsequent proceeding. However, the caveat being a party to the said suit cannot challenge the compromise effected between the parties to the suit by a verdict of the learned court. It is also the law of the land that in case of intestate succession, Hindu Succession Act applies. Hindu Succession Act will apply, but in the present case, there has been testamentary disposition of the estate. In paragraph 7 of their affidavit in support of caveat, they are continuously harping on the point that the family is governed by Mitakshara school of law. When the property was allotted in that proceeding as well, in the partition proceeding which happened, Devopriya Roy Chaudhuri, the caveator, was allotted several properties. If you can come to page 45, Your Lordship, of GS6. Schedule H.
Page 40 কি বলছেন GS6 এর page 40 কোন দিকে তাকিয়ে রাখিস
So there, the properties which are allocated to the caveator are all listed below. He was allotted around 7 properties, Your Lordship. In the same proceeding, the testatrix kindly comes to page 40. Those are the properties that are allotted to Chaya Roy Chaudhuri, the testatrix.
Yes.
So she has got 52H for her exclusive use and enjoyment. That is also written in page 31, last paragraph. That's written. That is for exclusive use and enjoyment of Chaya Roy Chaudhuri, the testatrix. It's expressly written, Your Lordship.
Okay.
Again on page 33, Your Lordship, paragraph F, it's again reiterated that Chaya Roy Chaudhuri will become the exclusive allottee of Schedule H properties. Paragraph F, page 33.
Whether, my lord, we are denying that?
No, the moment they are harping on the point that it's governed by Mitakshara law and succession, because the Hindu Succession Act will not apply to this, because Chaya Roy Chaudhuri was allotted this property for her own exclusive use and enjoyment. So they are saying that since I am the only son, I have got caveatable interest. Very well. They have absolutely got caveatable interest. But the thing is, the moment you challenge the ownership of the testatrix, it goes away, the caveatable interest. In the Lodha judgment, actually, I am led by Mr. Ratul Das. He's not today. He's on legs in court number 15. So a judgment was also provided to Your Lordship, the Lodha case. There also, they challenged the ownership of that. So the court didn't allow the caveat to be sail away.
But then in points affidavit in support of, he says that he is not challenging that.
Yes.
He is accepting the compromise decree.
Matter closed.
No, they are receding it right now, Your Lordship. But if you go by the See, in paragraph,
Decree has been passed in 52H, allotted to the mother, and that decree is accepted by the
Parties.
caveat,
Son.
son.
Yes.
So does this amount to the fact that he is challenging the title?
Yes, my lord. Great
No,
point, my lord.
that happened long back, your lordship. They are challenging it right now. That the mother did not have absolute ownership of the property. They are governed by Mitakshara school of law.
But the
So
decree
automatically
which
the
has been
co-parsoner
passed
will have interest over the
might
property.
in a suit.
Yes,
Can it be decided in a probate proceeding?
Yes.
The only question is that whether there is any challenge to the title. This he has shown that he has stated that he has accepted the compromise decree, and though 1/3 share 52H, which is a part of 1/3 share, fell on his, but that has been allotted to the mother, and they accept that.
Accepted.
52H is an exclusive property. No 1/3 in that. It's an exclusive property allotted to the mother.
1/3 from my share. From others property, which you have referred 7 properties. তুমি কি চাইছো ওইগুলো তোমার মামা নিয়ে যাক?
No, 7 proper. The thing is saying, your lordship, the 7 properties which my learned friend is saying, that was allotted solely to the caveator, which I have no opposition to that. I am only on the property 52H Bainandan Street, which was allotted to me. Now they are challenging my title, saying that we are governed by Mitakshara School of Law. Co-personally have got the interest over the property and all that. That's what I'm saying. And if your lordship, on the last occasion, your lordship directed us to file a written notes and argument. So I'm not prepared. I have not prepared that as of now. So if it's kept next week, then I'll file the written notes of argument, and the hearing can conclude on the next Thursday. They will also file, we'll also file, and it will conclude. Oh, if they are not willing to file, I am
Record
willing
my
to file.
submission. We are not challenging the title of my mother in respect of the properties mentioned in the will.
Please call. Or Mr.
So do I get an opportunity to file written notes and argument, your lordship?
I will. Will যে বলা আছে। ওহ, ওরা বেশি বুঝে। এতটা থাক না, 11 থাকুক আর 500 থাকুক, যেটা থাকবে সেটা পাবে। বুদ্ধি নাই।
Replies are also concluded on behalf of the applicant.
My lord, record by one line submission. We are not challenging the title.
He submits that the caveator Udayanaran Betal, caveator, is not challenging the title of the Discrepancies. What you will do? You will file written.
If your lordship permits me, then next week, if the matter is kept at the top of the list, I'll file it, and your lordship may be kind enough to.
কোর্টকে তো আমি নিজে বললাম, আমি নিজে ডিগ্রি অ্যানেক্স করেছি তো। আমার তো পিটিশনের ডিগ্রিটা আছে না? কোথায়? এই তো।
তাই করে দিন, তাই করে চলে This is matter. On.
রাহুল বল। আমি বলেছি যে আমি টাইটেল চ্যালেঞ্জ করছি, কিছু করবো। টেক রেস্ট।
He's made his submissions. I will file a written notes.
6th November. After the vacation, you file it. No, next round.
I need not to file any my lord written note. My lord. If I desire, my lord, I can. But when I am not, my lord,
Are you filing or not? Are you closing it? You will file only.
My lord, in that case, I can file it within by Monday. I can hand it over. By Monday, I can hand it over.
The 6th.
6th, very well.
Next দিন তো
এখন চাই।
Hello, this is my application where the property was sold twice by the. আমি petition দিই। আমরা এত দেরি করেছো, এতবার টাইম নিয়েছো।
Petition number 31. 23 has to be passed. You have completed, no?
Yes. No, no, that's
My lord, on the last occasion, my lord, when I started, my lord, the 2 or 3 submissions, my lord, I have made, my lord, on the point of maintainability. My lord, what is this? This is, my lord, application arises out of a ultimately suit for partition, which has been, as of today, my lord, disposed of. Now, my lord, my lord, this application arises, my lord, after, my lord, the final degree proceedings. My lord, this is admitted fact. I hope my learned senior friend is not denying that. Now, my lord, how far, my lord's hands, my lord, how far your lordship, my lord, can entertain this application? That is, my lord, a question, my lord, which has to be decided by your lordship in view of the fact that since after, my lord, the proceedings are complete, final decree has been drawn up, my lord, subject to correction has become functus officio. Therefore, by filing an interlocutory application, my lordship knows, interlocutory applications are filed to the aid of the main relief. Interlocutory applications are filed to the aid of the main relief. I will be, my lord, relying upon judgments on that. My lord, as of today, by filing this interlocutory application, my lord, may I ask myself, what, my lord, will be in the aid of the main relief? Because the main relief has already been achieved by the parties. This is a case which is application is not opposed by either by the plaintiffs of the defendants in the instant suit.
Yes, they are separate parties.
Exactly. Therefore, whether, my lord, by filing this, my lord, application, my lord, the ultimate, my lord, main parties to the suit, my lord, will have any benefit or not. Lordship has to, my lord, first take into, my lord, consideration of that. If, my lord, an interlocutory application which can be filed, my lord, to the aid of the main relief, and here main relief has been achieved, whether in this situation, my lord, whether this interlocutory application is maintainable, one. Number two, after passing of the decree, my lord, whether, my lord, has become functus officio or not, to give this relief to the applicant, because we both are, my lord, outsiders.
At the stage when the order was passed for sale of the property, whether the suit was disposed of or was pending.
That is at the, my lord, final degree stage.
So give me the dates.
final degree hoyeche ki? My instruction is final degree still not been passed. Otherwise, how could the sale orders be taking place? If the court was functus officio, how could the court be selling the property?
No, that is, my lord, I'll show you, lordship, the dates, my lord. Page 112.
In any case, what I'm complaining about is my vendor is the court. If any, I've been defrauded by the High Court. Because High Court has sold me the property. The High Court has to uphold my title. High Court is my vendor. High Court acts through the receiver.
One order is on, my lord, 15th January 1988 with, my lord, 103 of the of my affidavit in opposition.
If you know,
That is a math.
Thank you. Affidavit in opposition. Affidavit in opposition. Order passed on 9th of February 2024 by Justice Subhato Majumdar. A black sheet.
শিলাদিত্য বর্মার ভ্যাকসিন।
হ্যাঁ হ্যাঁ কিন্তু তাই একবার ফাইল করেছিল, অফার্ম না করে একবার ফাইল করেছিল অন্য লোকের নামে, তারপরে 3 বার
দেখুন এইটা এই 19th ফেব্রুয়ারি
কমিশন ডেট বলো না। মুম্বাই প্রিয়ামেটা
1st of September 2017 নরেন্দ্র লাল শীল।
না না ওটা
এটা
কেন,
না,
পেজ নাম্বার 14,
পেজ নাম্বার 14
প্রিয়াম এসে পড়ে গেল
15
11 নভেম্বর
11 November
তাই গেল না ওইটা
19th February 2024
19 February 2024
আসেনি ওটা অ্যাফিডেভিট অপারেশন
এই তো 19th
তোমরা অপোজিশন দিয়েছো না, এখানটা অপোজিশন
ওইটা প্রথমে যে ডেট কত
which page
103 মিলর্ড আর ওই সেলের অর্ডারটা বার করো ফটাফট দেখো বার করো।
My lord has the order sheets.
yes 103 here the been referring
My lord has the order dated 26 March 2019.
সেটা
আর এখানে বলছে suit has been suit was decreed in 1956. পেপারে কোনো ভুল ভাল করছে,
হ্যাঁ তো রেকর্ডেড
রেকর্ড করতে হলে তো তেলগুলো তোমরা
এটা কি
which order
I just came across the order passed by justice. I mean, there's some mistake there because, of course, this is a. Yeah, it says that the suit was decreed. My lord, I show my lord this. But this has to be referring to the preliminary. There's no final decree this time. This was random that came up and it was recorded.
But this is the order, Milord.
Yes, take a look at it.
Order, Milord, is February 6, 1987. Page number 64, Milord, of the of my same.
Four.
64 দেখুন February 6, 1987 এর order.
This doesn't say anything about the suit being disposed of.
No, order sheets.
My lord, as per the system, the final decree has not been passed as yet. Of course, final decree couldn't have been passed, otherwise,
okay let him so
Very well. Final degree is not been passed. Milord, I'll still, Milord, stick to point and I'll explain to your lordship, Milord. Still, Milord, this application could not have been filed. Still, I'll explain it to your lordship. One, number two, Milord, an interesting point, Milord, which was raised by my learned senior friend, is regarding Milord stamp duty. Milord, it says, Milord, my learned, so far as I can recollect, Milord, several months ago, Milord, he submitted that, Milord, my stamp duty is undervalued, which, Milord, he, Milord, intended to bring it to the notice of the court. As such, Milord, the deed, the fraud has been played. As such, Milord, it could not have been, Milord, registered. Milord, this was one of my.
I didn't say it couldn't have been registered. I said that was one of the prima facie indicators of fraud. Because the property, which was 20 years ago, valued at 7 lakhs, was sold 20 years later for 4 lakhs.
Very good. My lord is.
And the valuation was obtained not by the purchaser, but by the receiver.
Stamp Act, my lord, should not be. Very well.
Yes. Now, my lord, regarding that, my lord,
কপি আছে না বার করবো?
kindly soft copy আছে? নাই না।
Section
47A, 47B. Indian section, my lord, kindly see, my lord, 47A. There has been a West Bengal amendment.
47A of
Indian Stamp Act, my lord.
Dismissal amendment to 47A.
Yes. Of and I have the latest amendment.
is applicable to the state of West Bengal.
Yes, my lord, this West Bengal amendment. Yes.
If that is Punjab.
Kindly see, my lord, a detailed procedure is given if, my lord, what, my lord, the registrar has to do, my lord, if there is a deficit stamp. Well, kindly, my lord, once, my lord, kindly have a glance at the section 47A, and if somebody is aggrieved, what is the remedy under section 47B?
I've never argued that. I've never said that it is insufficiently stamped and therefore it should be set aside.
That is, you are taking it as a ground of fraud.
No, I've done it to demonstrate fraud.
Yes.
I've not taken it as a ground.
I'm replying to that only.
Okay.
Kindly see, my lord. Therefore, here in our case, my lord, the registrar has given a certificate on the last page of our deed that the stamp duty given is sufficient. Stamp paid is sufficient.
But at that point of time, there was no such procedure as we are following right now, that you have to get a valuation of the property. Thereafter, the stamp duty will be assessed.
My lord, perhaps there. My lord,
It was in
let me share.
2019.
No. Perhaps there. Perhaps
It was not
there.
there.
Perhaps there. Perhaps it was there. May I must check out the date of, my lord, the amendment. Date of amendment.
Date of amendment. Just
এটা তো 19 date 2019. 13. Now, my lord, kindly see in that book only, there is one rule which has been, my lord, which has come, my lord, under the West Bengal, my lord, undervaluation of stamp rules, 2001. In that, my lord, kindly see, my lord, A3, page A3. Rules start from there. May. No. Flag mark করে দিন।
Yes.
Well, kindly see, this is the rule, my lord, which has been, my lord, enacted, my lord, in this regard. Now, my lord, kindly see, my lord, page A31, the form.
Yes.
My lord, as of today, my lord, my client has never received notice under Rule 8. sub rule 8 of rule 3. Therefore, possibly, my lord, deficiency of stamp, my lord, cannot be argued before your lordship.
I have never argued it.
I have wrongly heard it.
I have never argued it. I said that's not even my case in the petition.
Oh, no, that is a ground of fraud. এইখানে ওইটা fraud দেখাতে পারবে? Good. Now, my lord, kindly see, my lord, what is the ultimate prayer in his application? His application is cancel my deed. That is his ultimate, my lord, prayer in the application. Now, my lord, whether that is maintainable that can be done, or that is maintainable by way of a, my lord, interlocutory application, or whether, my lord, your lordship, my lord, taking up an interlocutory application, my lord, can do it. Now, my lord, in that my lord, point, my lord, I'll be relying upon, my lord, section 31 of the Specific Relief Act. আছে আছে হ্যাঁ একেবারে বই আনবে তো খোলো তো ওটা পাওয়া যাবে মনে হচ্ছে section 31 is not required. It will be here. This single amendment I was not getting it. No, this is a 10, only 10 has been amended. Section 10 was amended, nothing else.
Section 31 of
Specific Relief Act, my lord.
Yes. Yes.
Application file করেছে দেখো। Any person against whom a written instrument is void or voidable, and who has a reasonable apprehension that such instrument is left outstanding may cause him serious injury, may sue to have it adjudged void or voidable, and the court may, in its discretion, so adjudge it and order it to be delivered up and cancelled. It says court may direct him to be delivered and cancelled. My lord, this is a suit, my lord. My lord has, my lord, seen many plaints where parties, my lord, seek for cancellation of duty. Then, my lord, kindly see subsection 2. If the instrument has been registered under the Registration Act, my lord, both the deeds are registration in terms of section 17 of the Act, of the Registration Act. The court shall also send a copy of its, kindly mark, decree to the officer in whose office the instrument has been so registered, and such officer shall note on the copy of the instrument contained in his book the fact of its cancellation. My lord, in no way in this application a decree can be passed. A decree for cancellation can be passed. It has to be by an independently constituted suit. Because subsection 1, he says, if the my lord, deed is allowed to be stayed, it will, my lord, cause serious injury to his right. That is section 31, subsection 1. Subsection 2 is, if it is application হবে না। If it is required to be cancelled, it has to be cancelled by a decree of court. And decree can only be passed after a suit is finally disposed of.
we stop here.
Madam, my lord, next Thursday, my lord, I am not here, my lord, after vacation. Next Thursday, my lord, impossible, my lord.
Opening এর এখানে ওপেনিং এর থার্সডে কত তারিখ হচ্ছে? ওপেনিং আমাদের কত তারিখ? 6th রাখো। রাখো।
হ্যাঁ 13th of
Mr.
November. My lord, in that case, would my lord fix it at 3:30? Otherwise, it'll never, every day it'll be heard for only 10 minutes in error. My lord has fixed the other matter on the previous day, so it will not clash. My lord keeps on the 13th, but fix it at 3:30.
The problem is that I can give you 3:30. But in 3:25, I take up a matter of the appellate side. It goes on to 3:45. That is
Very well. At least that will be the first matter in the list. If my lord says marks it at 3:30, it will be the first matter.
First matter ही रख दे. इटा first matter रख दे, ठीक है जी? दोनों भट्टाचार्य who places his points of argument due to paucity of time, hearing could not be concluded. This is matter on 13th. Copy থাকা 13th, হ্যাঁ? Mark করছি না?
May I have your lordship's extraordinary leave, my lord, to trouble your lordship, but I don't want to withhold your lordship for the cup of tea. But only they get, lordship kindly accommodate me, my lord. Item number 6, my lord, we are in great difficulty. Now, my lord, the problem is there is no board, and your lordship indicated that your lordship is inclined to form a board, to which I completely concede. My lord, I shall not trouble your lordship with who shall sit on the board or who shall do whatever. I shall completely leave it to your lordship. My lord, only sign.
My applications, my lord, also appearing as a new motions, my lord.
What is the main problem, my lord, is that we have to pay our class 4 staff. The receiver has been restrained because the court has said don't touch money, and I'm fully supporting that order. Now, my lord, interim board, if your lordship makes, of 3 persons.
My lord,
at least we can.
my lord,
do the
my
work.
new applications are appearing. My lord.
Grievances, my lord,
My lord, I have not got opportunity of making submissions, my lord, with my applications, my lord.
Poor men, the poor persons, my lord,
Yes.
they need money.
My lord, they obtained, fraudulently obtained an order, my lord, restraining me.
My lord, kindly see the interest of the receiver. How
My lord,
interested
a
they
recalling
are.
application is
Receiver
also.
is a person of the court. How interested they are.
Any day, any day. Lordship, kindly run
Their conduct apparents their misdeeds, my lord.
They need money, my lord.
My lord, they need
As
money.
if the receivership
recalling
is going
application of
and
that
they are
order is
restraining
pending
that.
before your lordships, my lord.
Do the
A
receiver has a
recalling
right, my
application
lord?
restraining the receiver is pending before your lordships, my
My
lord.
lord, that's
It
and they will
obtained
jettison the
fraudulently that
proceedings,
order,
my
my
lord.
lord. My lord,
They
I
will
place
jettison the
this
proceedings
application
like
before
that.
your lordships, my lord. I have
What
not,
is the interest of the receiver,
I
my
ca-
lord?
I have
Kindly appreciate.
my lord, I have not been
And
granted
lordship, it is a
opportunity of
specially
making
assigned matter,
submissions,
my
my
lord.
lord, in support of my recalling applications.
My lord, I cannot go anywhere. My lord, kindly
My
consider
lord,
my fate. My
they
lord,
have fraudulently
specially assigned
obtained
matter,
the
my
order
lord.
from this, from the honorable court, my lord.
my lord.
My lord,
My lord,
I
kindly, my lord.
took up a recalling applications.
Quarreling, my lord. We are not on a quarrel.
It is specially assigned.
My lord, allow me to make submissions only.
Only the poor people, my lord, what face we will have, my lord, today.
It is a specially assigned matter where they will, where the litigant will go, my lord.
Placed with your lordship. My lord, 2 new applications have
And
been
where will the
filed by
litigant
me, my
go?
lord.
Poor Darwan, he's been paid for 9 months.
My lord, they fraudulent. My lord, I shall just kindly have a look at it. My lord, I shall
Kindly
demonstrate.
see the interest of the
My lord,
receiver. He is a court
fraudulently
appointed
they
person.
took out these applications and obtained the order. My lord,
My lord, kindly, my lord, I am
they would stifle my voice and get the order behind my back. My lord, that is only their objective.
Every court has obstructed you.